The Supreme Court has held that the Asda employees working in Asda's retail business, bringing equal pay claims, can compare themselves with Asda's employees working in the distribution centres. Men and women have the right to equal pay if they're employed on equal work, which covers like work, work rated as equivalent under a job evaluation scheme, or work of equal value. In this case, the retail staff have claimed that their work is of equal value to the work of the distribution centre staff. The preliminary issue that the Supreme Court has had to decide is whether the retail staff can compare themselves for pay with the staff located at the distribution depots, which are separate to the retail locations. The relevant section of the Equality Act effectively states that the comparator must be employed by the same employer or an associated employer at the same establishment, or employed by the same employer or an associated employer at a different establishment, but common terms apply at the establishments. The Supreme Court had to determine how you apply the common terms requirement. The Supreme Court determined that the correct approach was to ask whether, assuming that the distribution staff were employed to do their own jobs at the retail staff's locations, would their existing terms and conditions apply? It was incorrect to perform a detailed comparison exercise between the terms of the retail staff and the terms of the distribution staff. Importantly, the Employment Tribunal had earlier found that the distribution staff would have been on substantially the same terms and conditions had they been employed at the retail staff's locations. On applying their reasoning, the Supreme Court held that the retail staff could compare themselves with the distribution staff, and that Asda's appeal was dismissed. It's important to emphasise that the Asda employees have only won on the preliminary point. They will now need to go on and show that their work is of equal value to the work of the distribution staff, and if so, there are no genuine material factors which are neither indirectly nor directly sex discriminatory which justify the difference. The decision nevertheless is a big step for the employees, and no doubt other supermarkets facing similar claims will be concerned. For more information, do browse this channel and visit my website. Remember that this video is for guidance only and should not be relied upon for specific advice. Also, the law can change. And finally, please subscribe to this channel for updates.